Welcome to the Kids Caught in the Middle video series. Today's episode, we're going to talk about Chapter 7, Grandparenting Time. My name is Liisa Speaker, and I wrote the book, Kids Caught in the Middle, How Families Are Harmed When Judges Don't Follow the Law. Now, parents are allowed to make associational decisions for their children, and this includes whether the children spend time with their grandparents. Grandparents can request that a court order that they receive grandparenting time, but only under limited circumstances. Some of those limited circumstances include if the parents have never been married to each other, if the parents are divorced, or if one of the parents dies and the parent who died happens to be the child of the grandparent who's seeking grandparenting time. But if two parents come together, whether they've been married before or not, if they come together to deny grandparenting time, the grandparenting case should not be able to move forward. Now, grandparents have a high burden to meet in order to prove that they should get grandparenting time from a court, because they have to prove that the child will experience a substantial risk of harm to their physical, psychological, or emotional well-being by denying grandparenting time. In order for grandparents to meet this high burden, they really need to have an expert witness who can provide the expert testimony about that substantial risk of harm by denying grandparenting time. And there are a lot of cases out there, Court of Appeals decisions, that talk about whether a grandparent did or did not have sufficient evidence, including expert witness testimony. It's always a good idea to go ahead and get that expert witness if you think you want to make sure your clients have a chance of having grandparenting time awarded. There have been a good number of reversals by the appellate courts in grandparenting time cases because the trial court did not make appropriate fact findings to justify the award of grandparenting time. And that could have been a failure to show that there was a substantial risk of harm, for example. Also, judges sometimes like to make interim orders to give the grandparents some time even while they're waiting for the evidentiary hearing, but that is not appropriate because in order for even an interim order to go into effect, the judge needs to have that evidence of substantial risk of harm in denying grandparenting time, even to do an interim order. So that is definitely an appealable issue. It should, I think, be appealed right away. And the dynamics in grandparenting time cases sometimes are a little weird. You would think it's the grandparents versus the mom or the dad, but a lot of times the reality is that the mom or dad is not really around, and their parents are the ones who are opposing grandparenting time, but on paper it's the mom or dad. And so technically that's correct that it's grandparents versus mom or dad, but in reality it's grandparents versus grandparents who are fighting over who gets to see the kid. So just be aware of those strange dynamics. Now, I wrote a guidebook to help trial attorneys be prepared for court. It's basically a summary of the Kids Caught in the Middle book. And if you're interested in getting a free copy for yourself or for your attorney, click on the link below.